Good afternoon and welcome to The Insurance Lawyer, the podcast where we discuss topics concerning claims and lawsuits between insurance companies and their policyholders. I am your host, Evan Schwartz, founding partner of Schwartz, Conroy & Hack. The firm represents business and individual insurance policyholders in claims and lawsuits against their insurance companies, helping their policyholders get their claims paid. Today, I'm going to talk to you about a relatively famous case in the long-term disability sphere known by most people as the Unum Provident class action. The Unum Provident class action was a lawsuit that I envisioned and crafted with my law firm and filed back in 2002. And there is a long history associated with the case, and there's plenty of stories that I could share about this case. But for purposes of today, I just want to talk to you a little bit about how the case came to be and what it did to sort of change the law in the world of class actions and claim practices class actions. Before the lawsuit was filed in 2002, there's a little history that's worth explaining. To begin with, the entire long-term disability industry went through a major shakeup after calendar year 1995. At that time, interest rates had dropped. Managed care had risen. There were quite a number of claims being filed against long-term disability companies that were having a major negative impact on their bottom line. They were losing money in the market because the interest rates were low. The claims were pouring in. All of a sudden, what looked like this amazing book of business for long-term disability insurance companies and insurance companies that sold the product suddenly was not such a great business for them. And at the end of 1995, the companies responded by shutting down claims, terminating claims, denying claims, and that ultimately led to a major amount of claims and lawsuits all over the country. It also resulted in a major change in the long-term disability insurance company where there was major consolidations. Many companies stopped selling. Many of them went into runoff. Many of them outsourced their book of business to other companies to either manage or sold it. By the time you got into the new century, there were many less companies selling it, and the products were not nearly as generous as they were prior to 1995. At that time, the largest company selling and administering long-term disability insurance in the United States was, and I believe still may be, Unum Provident Corporation, often known as Unum. Unum Provident was a merger of two major both group and private disability insurance companies, Unum Life Insurance Company and Provident Life and Casualty Insurance Company, that merged together to form Unum Provident. They merged in 1999 and under the new consolidated management also joined in the fray that had already started of questioning, denying, and terminating long-term disability claims. At the end of 1995, I was a young lawyer who had been practicing just a little bit more than 5 years, and I had represented insurance companies at big law defending all kinds of insurance coverage issues. I switched sides and formed a law firm with a former partner, and we opened our doors on January of 1996 and positioned ourselves in the market as a law firm that represents policyholders in claims and lawsuits against insurance companies. Now, at that time, there was no internet, and your means of marketing or advertising were far more limited, and your reach was far more limited. But we put out an advertisement in the Yellow Pages touting ourselves as lawyers that will help you with your insurance claims or litigation. In 1996, when that ad came out, is coinciding with the same time that all of these companies changed their claims model and began questioning, denying, terminating, and buying out long-term disability claims. As part of what we were doing on the side of the insurance policyholders, we started to get numerous calls from our Yellow Pages ad. The vast majority of those calls were from people in the medical field, orthopedic surgeons, anesthesiologists, podiatrists, chiropractors, and all other forms of healthcare providers, mostly MDs, as well as dentists. We also got lawyers and business owners and high wage earners and all kinds of other clients as well, but that was a massive influx because those types of professionals were the people who bought those policies and had the policies marketed to them. So there we are, this little firm in 1996, and these claims start pouring in. We grow the firm to the point where we're handling a substantial number of them, both in the claims process and in litigation. During that time, between 1996 and 2002, with the rise of the internet, we get a website. Long before Google takes over the universe of the internet, there are about 5 or 6 web search companies out there, and we wound up nationally ranking very high because of the content we had on our website for long-term disability, and started to get inquiries and claims from people all over the country. Also at the same time, there was a realization by a lot of these insurance companies that if they were able to get a federal law called ERISA to apply to the management administration of the long-term disability claims that were being made by their insureds, that they could take advantage of that federal law and federal regulations. So as part of the whole change in the industry and the shutting down of claims, we started to get an enormous number of inquiries from people all over the country that had ERISA-governed long-term disability claims. And a lot of those claims were very, very small. But what was happening to these people when we were doing the intakes and looking at these claims was terrible. The way they were being treated by the insurance companies was terrible. Unum Provident was a huge, huge percentage of the people that were contacting us. We're not that large of a firm, and we're getting inundated with these claims, and we're trying to figure out which people we can help, which people we can't help, and how to deal with this volume. So it's just seeing the number of people that were being what we believe to be unlawfully and illegally shut down and not given their benefits at a very, very vulnerable time in their lives. And so we wanted to do something about that. In addition to the information we were able to get against Unum Provident through the management of our own claims and the litigations we were handling on behalf of clients and the discovery, there was an associate medical director that worked for Unum Provident that was fired, and he commenced an action against Unum Provident relating to his discharge. He testified in a deposition, and in that deposition, he swore to the fact that Unum Provident was engaging in a lot of unlawful and smarmy practices designed to shut down claims. I'm in my office working late one night with my now partner, Michael Hack, and Michael Hack is reading this associate medical director's transcript of his testimony. His name was Patrick McSharry. He keeps interrupting me and coming down to my office and saying, "Evan, look at what this guy's saying. Look what he's saying about this. Look what he's saying about that. Look at what they're doing to shut down these claims. We have to do something about this." And so it's got to be probably 7:30, 8 o'clock at night. We're having another late night in the office. And I've been thinking about this as well. I walk down the hall and I pull out a law book, what we call a treatise, that is a discussion of a specific area of the law. And this particular treatise is about ERISA litigation. And I'm reading the treatise and I see that there are areas of ERISA that I think could be used to bring a much larger case against an insurance company for their misconduct. And in this particular case, the focus was on Unum Provident. Just to understand the difficulty of this, it's extraordinarily difficult, if not impossible, to bring a claims practices class action involving people with disabilities against an insurance company. And the main reason for it is that class actions require common issues of law and or common issues of fact, that everybody basically the same issue that they want to prosecute in order to get relief or get a remedy from the bad guy or the defendant. When you're in the long-term disability space, it's impossible to come up with common issues of fact, but common issues of law as well, because everybody's got a different disabling condition. Everybody's got different policies, different definitions in their policies. They were sold by different companies. They say different things. Everywhere you turn, everything about each person's individual case is uncommon. No one had ever really brought a claims practices class action before. The difference in ERISA is that there were provisions where you could bring a lawsuit and seek to go after a company for things other than the claims practices themselves. So as an example, when an insurance company has been designated to administer benefits on behalf of an employer under ERISA, they are considered to be a fiduciary. They're a fiduciary assigned by the employer to handle the claims and the appeals under ERISA. There's a claim under ERISA for breach of fiduciary duty. There's a section that says if you're a claims administrator or a plan administrator, you have to discharge your duties solely in the interest of the participants and beneficiaries for the exclusive purpose of providing benefits to them with care, skill, prudence, and diligence of a prudent person. If you don't do that, that's considered to be a breach of fiduciary duty. There are also other sections by which you can go after a fiduciary or a claim or plan administrator for their conduct as a whole, as opposed to looking at the individual claim. That's where the genesis of our theory came from. And the theory was that Unum Provident, as we alleged in the complaint, in the class action complaint that we ultimately brought in November 2002, that we said, hey, you, Unum Provident, are engaging in a series of practices in your claims management that are all unlawful and that are all harming the beneficiaries of these plans, the people who are disabled and seeking benefits. All of those acts are done through a global plan and scheme by you because you are budgeting and targeting claims, meaning you're setting financial budgets and you're basing your decisions on whether to pay or deny claims on the targets you want to reach with your budget. So you're saying each quarter you want to minimize the total dollar amount of claims you're paying by X dollars, and you have a specific target, and that in order to reach that target, you're engaging in a series of bad acts to get there, in terminating and denying claims across the board. So besides instituting these targets, these budgets, and these goals for cost savings, some of the allegations included providing financial incentives to the in-house doctors so that they would ignore their ethical obligations and rubber stamp denials or terminations, reward management for denying claims, authorizing senior in-house medical professionals to alter the written reports of uncooperative other medical professionals to justify the denial or termination of claims, hiding documents and creating secret files that allowed you to mask the misconduct, encouraging a game amongst the doctors, which plaintiffs on both the insurance recovery and personal injury side would call insurance company medicine, which involves changing valid medical opinions, closing their eyes to other medical evidence that support a claim, remaining quiet about their personal medical opinions, especially if they were going to suggest that other testing or analysis be looked at, putting canned statements into reports. In addition, the allegations including recruiting specific personnel who had a reputation for shutting down claims. And finally, using a system which would prevent someone from looking at somebody's multiple disabling conditions as a whole and just targeting one condition to suggest that that condition itself is not disabling, even though they're suffering from a whole bunch of other conditions. Basically, what we were saying was, you have budgeted your claims process. That's illegal. You've done it through a series of bad practices. And we're not saying that as a result of that, you denied any one individual's claim. As a result of that, the factory through which the claims process was working was a tainted, dirty, contaminated factory. Our theory was basically, you need to go in, you need to clean the entire factory, and you need to take all the claims and rerun them through the factory. And if some of them get paid, they get paid. If some of them get denied or terminated, they get denied or terminated. But you basically need to do your claims process all over again, and you need to do it in a clean process. That's how we were able to allege. And that was my theory, that we could say, hey, your breach of fiduciary duty was budgeting and targeting your claims process. Here's the examples of how you did it. You need to stop doing it. So we wanted an injunction. You need to clean it. You need to run the claims through, and you need to start over again. And as a result, lots of claims will probably get paid. Doesn't mean all of them will get paid. That's what ERISA and the law of ERISA enabled us to do in filing this case. At the end of the day, it worked in the sense that the case ultimately involved helping change the law, where ultimately Unum Provident also got investigated by all of the state insurance departments across the country and ended up settling with almost all 50 states by doing exactly what it is that our lawsuit asked to be done. Run the claims over again, re-review them, and do it in a fair process. In addition, we were able to successfully survive a motion to dismiss and move the case forward. But the tale of what happened in the case and all of the things that went on in that case afterwards is a whole nother subject of another podcast if I ever decide to do it. In any event, it really did change the industry. It changed how people looked at opportunities under ERISA. It had a chilling effect on a lot of other companies that had been engaging in similar practices because they did not want to go through the rigmarole and the ringer that Unum Provident all went through when they were charged with engaging in this type of unlawful conduct. Now, for anyone who's interested, the complaint is on file, still in federal court. It's at docket number 02CV8781. It's in the United States District Court for the Southern District of New York, and it's entitled Kier versus Unum Provident Corporation. Those are the first two names of the plaintiff and the defendant. There were other named plaintiffs and other named defendants. That's the case. For me, it turned out to be an almost 10-year saga, but looking back, both my partner Michael and I and the firm feel very, very good about how we were able to help a massive number of people that we just couldn't help with our law firm on a one-in and one-out basis. So I thank you for listening today, and if you like the podcast, make sure to leave a review and subscribe so you don't miss an episode. You can visit the Schwartz, Conroy, and Hack PC website at www.schlawpc.com for more information. I am the insurance lawyer. Have a wonderful afternoon.